support. And this means greater terror for the people in northern Nigeria and greater challenges for Nigerian security forces. Unfortunately, these forces suffer unprofessional elements with poor morale. I have been in Nigeria several times. It is a struggle for the Nigerian military to cope with this threat. And that's led some to say that we should not get involved. But it tells me otherwise. It tells me that U.S. involvement is critical. U.S. forces are well positioned to advise and assist. We can advise and assist Nigerian forces in the search and the rescue of these girls. In this role, U.S. forces expertly trained to deal with hostage situations and in jungle environments and in tracking could help Nigerians with intelligence, planning, and logistics. And if some U.S. laws would hinder such assistance, the administration should use its waiver authority under these extraordinary circumstances. Why do we care? We care about Deborah, her friends and family. We care about a girl's right to an education. We care about human rights and religious liberty and the future of Africa's largest country, largest in population, largest economy. And we have direct security interests. Commanders at the Pentagon have stated that Boko Haram is, in their words, a threat to Western interests and one of the highest counterterrorism priorities in Africa. Pressure from this committee was critical in getting the State Department to designate Boko Haram as a foreign terrorist organization. Indeed, the administration made that announcement in this room under pressure from us on this committee. As many have noted, it shouldn't have taken so long. We want to hear from the State Department and the Pentagon witnesses on the strategy we now have in place. Boko Haram, with heavy weapons and grenade attacks, is waging a brutal war against schoolgirls carrying backpacks and books and pencils. We can't sit on the sidelines. And I'll now turn to the ranking member for his opening comments, Mr. Elliott Engel of New York.
Thank you, Mr. Chairman, and thank you for holding this very timely hearing on Boko Haram. I'd like to thank our witnesses, Dr. Sewell and Ms. Dorey, for being here today. And, of course, I'd like to welcome Ms. Deborah Peter, a brave young survivor of a Boko Haram attack in 2011. She met with members of this committee earlier this morning to describe her harrowing experience. Deborah, we are all grateful for your courage and your commitment to seeing that these horrible abuses are stopped so that no other family goes through what your family has gone through. Thank you for your courage. We're all very, very proud of you. And I must also say that since I had the opportunity to meet with her privately, how proud any parent would be of having a daughter like Deborah. So thank you, Deborah. Mr. Chairman, Boko Haram is an Islamic extremist group increasingly active since 2010 that operates mainly in northern Nigeria. As we all know, one of Boko Haram's most recent atrocities took place on April 14th of this year. That day, nearly 300 schoolgirls were doing what young women and girls all over the world do every day, studying for tests, playing with friends, building a future for themselves. That day, Boko Haram, which roughly translates to Western education is forbidden, abducted these girls, tore them away from their families and their communities. Today, more than a month later, we still don't know where they are. Our thoughts are obviously with their families, and we pray that they are safely reunited as soon as possible. The United States and other international partners have offered assistance to bring the schoolgirls home, and we all hope those efforts will prove successful. I agree with Chairman Royce that we must do everything in our power to bring those girls home, and the United States can be very helpful in assisting this process. But even as we work to address the crisis, we need to focus on the larger challenge, stopping Boko Haram's reign of terror in Nigeria and beyond. Just yesterday, Boko Haram set off 2 bombs in the city of Jos, killing over 100 people, 100 innocent people. 2 weeks ago, the group attacked a market in the town of Gambaru, killing more than 300 people. And back in 2011, in one of their most high-profile attacks, the terrorist group bombed the United Nations headquarters in Abuja, killing at least 21 people and injuring more than 120. You really have to be bold to attack a United Nations headquarters. So all told, Boko Haram has murdered more than 5,000 people over the last 4 years. Their victims are both Christians and Muslims, men, women, and children, and of course teachers. Before this brazen kidnapping, Boko Haram was virtually unknown around the world. As more of their violent history has come to light, the international community has reacted with shock, horror, and disbelief. But the sad reality is that Boko Haram is not new, and neither are their tactics. I think our witnesses can shed more light on the situation for us and for everyone following the plight of these young girls. How did Boko Haram emerge and grow into an extremist threat? What has allowed them to thrive as an organization? And what challenges does the U.S. face in working with Nigeria to disrupt and dismantle the group? Let me just say that contrary to some of the reporting I've seen, I know the difficulty in weakening Boko Haram has not been due to a lack of effort or an unwillingness to help. In fact, one of our major challenges is working with the Nigerian military itself. Its approach in northern Nigeria has often alienated the very population that could be providing valuable information about Boko Haram's activities. But instead of forming these relationships, unfortunately, the military has too often built a record of indiscriminate destruction themselves, theft of personal property, arbitrary arrests, indefinite detention, torture, and extrajudicial killing of civilians, much of this with impunity. In addition, despite a recent intelligence sharing agreement, there are legitimate concerns that intelligence shared with the military to assist them in their operations might be leaked. And to make matters worse, this corruption, it's rampant throughout the force. Nigerian security forces are the best funded on the African continent, yet many of the funds are siphoned off by corruption, while troops often aren't paid a living wage, generating increased frustration in the ranks and fueling low-level corruption. So how exactly can the U.S. engage with a military force that sometimes lacks professionalism and often seems to fail to respect human rights? And how do we convince Nigerian leaders that they aren't doing enough and, in fact, may be making the problem worse? Lastly, while we are very focused on recovering these girls and stopping Boko Haram, we need to look at the broader context. Years of economic stagnation and neglect have afflicted northern Nigeria and created the sort of environment where terrorist groups thrive. In places where there is no support or opportunity, extremists find it easier to prey on vulnerable populations, preaching false ideologies of violence and hatred. To push back against this tide, I believe Nigeria's government must address these issues of corruption, improving economic activity. In short, Nigeria must take a more holistic approach to counterterrorism. So I look forward to hearing from our witnesses about how the U.S. can more effectively engage with the Nigerians to address the scourge of Boko Haram today. I regard Nigeria as our partner in this, and the United States needs to be helpful to them. We need to build an environment that fosters development and prosperity in northern Nigeria for tomorrow. So thank you, Mr. Chairman, for holding this hearing, and thanks to the witnesses and Deborah for appearing here today.
Thank you.
I yield back.
Thank you, Mr. Engel. We go to Mr. Chris Smith, Chair of the Africa Subcommittee.
Thank you very much, Mr. Chairman. And again, thank you for convening this extremely important hearing. Obviously, words are inadequate to express our concern, and I say that collectively for all of us, for the welfare and whereabouts for the abducted girls, as well as the outrage towards Boko Haram for this absolutely horrific act of aggression and violence against these young women. My good friend and colleague, Mr. Engel, just mentioned how Boko Haram was largely unknown around the world until this infamous incident. But not to Chairman Royce or Elliot Engel or Ranking Member Bass or me or any other member of this committee. We have been raising the concerns of Boko Haram for years, especially since 2011, when they seemed to transition into a more lethal stage with the bombing of the UN mission in Abuja, but also the very real problem of not being designated a foreign terrorist organization. I held 2 hearings on Boko Haram. Emmanuel Ogebe was at one of those hearings. Matter of fact, I went with him. He joined us in Jos and in Abuja. And we met with people who have been the victims of fire bombings, Christians, as well as some Muslims who were targeted for killings by these thugs. And he made it very clear then, and he is now accompanying
perspective, there are no barriers to repeal and no deficiencies of needed authorities to assist the government of Iraq in counterterrorism activities. These are important questions that must be answered. Now, not at a moment of crisis, is a time to have this important dialogue. There is no issue more important to our national security than whether to use military force. And there is no other committee in the Senate that is seized with this issue more squarely than the Senate Foreign Relations Committee. Current and future threats necessitate our engagement and our attention. So with our thanks to the witnesses again for what I look forward to be an informative exchange, let me, before I turn to Senator Corker, we have received a statement for the record from the Human Rights First on the issues we will cover in this hearing. I ask unanimous consent that they be included in the record. Without objection, so ordered. Let me recognize the distinguished ranking member, Senator Corker, for his remarks.
Mr. Chairman, I want to thank you for having this hearing, and I want to thank the witnesses for taking their time to be here before us today and help us. And I want to thank you on 2 fronts. Number one, I know we've talked about this for some time, and you've honored a commitment, which I greatly appreciate, actually to people on both sides of the aisle. And I appreciate the way you've allowed there to be appropriate debate on this committee. I know we both attended a sort of a discussion last night that I found to be one of the most bizarre I've attended on foreign relations, on foreign policy in our country, and I'm convinced more than ever that this discussion regarding the AUMF is an important place for us to weigh in and to help shape policy. And I want to say on the onset that to me, this is not about trying to limit the President in his abilities to carry out activities that I think both of us consider to be very, very important to our security. It's more about us weighing in and actually giving the President the authorities he needs, but at the same time, us having the responsibility to ensure that we have appropriate policies, especially with where we are today relative to terrorism around the world. So with that, I'm going to read, I hate to read opening statements, but I'm going to do that anyway. And again, I want to thank you for allowing us to weigh in on one of the most critical issues facing our country. My hope is the committee can lead Congress to fulfilling its constitutional responsibilities in foreign policy and ensure that we as a nation pursue our national defense in a lawful and accountable way. 1 week after the 9/11 attacks, Congress authorized the President to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September the 11th, 2001. More than 12 years later, the President continues to rely on the same 60-word authorization to fight terrorist organizations around the world. I understand why people are concerned and may think that seeking appropriate legal authorization for counterterrorism is either a way to seek expansion of war or attempt to restrict the President. From my perspective, neither is the case. In the 13 years since the original authorization, the threat to our security has changed substantially. Today's threat is no longer about the hunt for bin Laden and those responsible for the 9/11 attacks. Today's threat is about affiliated groups metastasizing across the globe, and the current authorization simply does not make sense anymore. These evolving threats are not secret, and they're clearly openly recognized by this administration. A State Department report released in April said that while al-Qaeda's central leadership is diminished, their affiliated groups are expanding. contributing to a 43% increase in global terrorist attacks in 2013 alone. Chairman of the Joint Chiefs, Martin Dempsey, recently testified that the terrorists responsible for killing 4 Americans in Benghazi are not covered under the current AUMF. Perhaps the most problematic and ironic is the fact that the President may not have the authority to target the most ruthless terrorist organization in Syria, the Islamic State of Iraq and Syria, or ISIS, because of its split with al-Qaeda. It would be easier for us to ignore these difficult issues or to buy the fantasy that al-Qaeda is dead or dying and that the tides of war are receding. But no serious observer can look to the world today without concluding that for the foreseeable future, terrorist groups with global reach will continue to threaten our country regardless of their link to the 9/11 attacks. Rather than abdicating the responsibility for confronting this threat and leaving it to the executive branch, Congress has a responsibility to both provide the President with the legal authorities needed to ensure our security and to define the legal parameters in which this shall be pursued. This hearing provides members of this committee the opportunity to begin that process. However, since the President suggested in a May 2013 memo that he would engage with Congress on this issue, he has been silent and done nothing. I believe this committee can and will act responsibly. I believe we can move forward in a bipartisan fashion to ensure that the law reflects reality, that counterterrorism operations respect the law, and that the President has the authority that he needs to keep America safe while respecting the Constitution. This hearing is a first step in that direction. The bottom line is that an issue this critical to our security and liberty demands a robust and thorough debate from the elected officials of the American people. As difficult as it may be, Congress has to step up to the plate. It's our duty to have this debate. We cannot ask Americans to serve their country and risk their lives in the ongoing fight against terrorism if we will not take our responsibility seriously here. So with that, Mr. Chairman, thank you again for this great hearing, and I hope we'll have some results after this hearing is concluded.
Thank you, Senator Corker. I understand that a class from Jefferson High School of Alexandria, Virginia is with us. We welcome you all to the Senate Foreign Relations Committee today. It's a great topic for you to be listening to as we move in the course of events here, so welcome. Our first panel, we have Mary Mcleod, the State Department's Principal Deputy Legal Advisor, and Stephen Preston, the General Counsel of the Department of Defense. Your full statements will be included in the record without objection. I'd ask you to summarize those statements in about 5 minutes or so that the members can engage you in a question and answer session. And with that, Ms. Mcleod, you're recognized.
Thank you very much, Chairman Menendez, Ranking Member Corker, and members of the committee for the invitation to speak at this hearing. The administration looks forward to engaging with this committee and the Congress on this important topic. I'll begin with some introductory remarks before discussing briefly a few international law aspects of the administration's legal framework for conducting operations pursuant to the 2001 Authorization for Use of Military Force, or AUMF. I will conclude by laying out a few relevant considerations for establishing our legal framework beyond 2014. My colleague Stephen Preston, General Counsel of the Department of Defense, will then address the current framework under U.S. law for military counterterrorism operations. As an initial matter, as you noted, the President has made clear his desire to engage with Congress about the future of the AUMF. The President expressed his commitment to move America off a permanent war footing 1 year ago in his speech at the National Defense University and reaffirmed that commitment in this year's State of the Union address. And the President made clear in his NDU speech that his goal is to engage with Congress and the American people to refine and ultimately repeal the AUMF. As we begin our dialogue on this issue, it will be critical to assess our legal authorities, not only within the context of our current military operations, but also in light of future needs, which as of today's hearing may not be fully apparent. At the same time, as the President has said, we must keep in mind going forward that not every collection of thugs that label themselves al-Qaeda will pose a threat to the United States that requires the use of military force in response. Turning now to international legal considerations. As we consider the future of the AUMF, it will be critical to ensure that U.S. actions continue to be grounded firmly in international law. Under international law, the United States has an inherent right of self-defense to use force to respond to an armed attack or to the imminent threat of an armed attack. And when in an armed conflict, the United States may use force in accordance with the law of war to prosecute that conflict. Our use of military force must comply with international law's requirements of necessity, proportionality, distinction, and humanity. United States use of force abroad is carried out in furtherance of these international law rights and requirements, and the law of war specifically has and will continue to provide the legal framework for U.S. military actions taken in the armed conflict against al-Qaeda, Taliban, and associated forces. Going forward, the Office of the Legal Advisor at the State Department will continue to work to ensure that we exercise our rights consistent with these and other applicable international law principles. I also want to note that there is a firm basis in international law to support our friends and partners facing the threat of terrorism within their own borders. Even where violent extremists pose a greater threat to those countries than they do to the United States, we can draw from all elements of national power, including military force in appropriate cases, to help them counter these threats. In Mali, for example, we've been providing military aid to French forces to push back terrorists and other extremists. As the President stated in his speech 1 year ago, we must define our effort not as a boundless global war on terror, but rather as a series of persistent, targeted efforts to dismantle specific networks of violent extremists that threaten America. Indeed, targeted efforts undertaken in partnership with other countries can be highly effective in countering terrorist threats without keeping the United States on a permanent wartime footing. With these principles in mind, let me now outline a few considerations regarding a future legal framework. We're currently working to identify an appropriate U.S. military presence in Afghanistan after 2014. We're also working toward the closure of the detention facility at Guantanamo Bay, which the President has reaffirmed will further our national security, our international standing, and our ability to cooperate with allies in counterterrorism efforts. We also continue to work with our allies and partners to provide assistance and training to increase their capacity to take effective measures against terrorist organizations. The State Department is joined by many other U.S. agencies in implementing this comprehensive strategy, which includes a broad range of military and other foreign assistance, law enforcement cooperation, intelligence sharing, and diplomatic engagement. All of these efforts are vital to countering threats. This is true even at times, such as the present, when we are using military force as part of our response to the terrorist threat. In the long term, the success of our efforts will depend not exclusively on the use of military force, but also on sustained attention to achieving effective governance and the rule of law in countries where terrorist threats proliferate. And based on all these considerations, we would suggest that our efforts to identify a future legal framework be guided by the following principles. First, any domestic authority that we rely on to use military force should reflect the President's clear direction that we must move America off a permanent wartime footing. As the President stated, this means that we will engage with Congress and the American people to refine and ultimately repeal the AUMF, and that the President will not sign a law designed to expand the AUMF's mandate further. Second, any authorization to use military force, including any detention operations, must be consistent with international law. Third, we must continue to enhance our cooperation with partner nations to take action within their own borders, including law enforcement action and other forms of engagement, where those methods provide the most effective and sustainable means of countering terrorist threats. Finally, we must keep in mind that the President's authority to defend the United States would remain part of any framework that emerges. Thank you very much, and I'll now turn to Stephen Preston to make his statement, and after that, we'd be happy to answer any questions you may have.
Mr. Preston.
Thank you, Mr. Chairman, Ranking Member Corker, and members of the committee. Appreciate this opportunity to appear. I'd like to open with a brief discussion of the current legal framework for U.S. military operations, focusing on how the 2001 authorization for the use of military force is being applied by the Department of Defense. Although the AUMF makes no express mention of specific nations or groups, it was clearly intended to authorize the President to use force against al-Qaeda, the organization that perpetrated the 9/11 attacks, and the Taliban, which harbored al-Qaeda. In addition, based on the well-established concept of co-belligerency in the laws of war, the AUMF has been interpreted to authorize the use of force against associated forces of al-Qaeda and the Taliban. As the administration has stated publicly on numerous occasions, to be an associated force, a group must be both an organized armed group that has entered the fight alongside al-Qaeda or the Taliban, and a co-belligerent with al-Qaeda or the Taliban in hostilities against the United States or its coalition partners. The Department of Defense relies on the AUMF in three contexts: ongoing U.S. military operations in Afghanistan, our ongoing military operations against al-Qaeda and associated forces outside the United States and the theater of Afghanistan, and detention operations in Afghanistan and at the Guantanamo Bay, Cuba facility. In Afghanistan, the U.S. military currently conducts operations pursuant to the AUMF against al-Qaeda, the Taliban, and other terrorist or insurgent groups that are engaged alongside al-Qaeda and the Taliban in hostilities against the United States and its coalition partners. In addition, the ISAF and U.S. rules of engagement permit the targeting of hostile personnel in Afghanistan based on the threat they pose to U.S., coalition, and Afghan forces or to civilians. Outside the United States in areas of active hostilities, the U.S. military currently takes direct action under the AUMF, that is, capture and lethal operations, in the following circumstances. First, in Yemen, the U.S. military has conducted direct action targeting members of al-Qaeda in the Arabian Peninsula. AQAP is an organized armed group that is part of al-Qaeda, or at least an associated force of al-Qaeda, for purposes of the AUMF. Second, the U.S. military has also conducted capture or lethal operations under the AUMF outside Afghanistan against individuals who were part of al-Qaeda and targeted as such. For example, in Somalia, the U.S. military has conducted direct action against a limited number of targets who have been determined to be part of al-Qaeda. And in Libya, in October 2013, in reliance on the AUMF, U.S. forces captured longtime al-Qaeda member Abu Anas al-Libi. Now, the fact that an al-Qaeda affiliated group has not to date been identified as an associated force for purposes of the AUMF does not mean that the United States has made a final determination that the group is not an associated force. We are prepared to review this question whenever a situation arises in which it may be necessary to take direct action against a terrorist group in order to protect our country. Lastly, in our ongoing armed conflict against al-Qaeda, the Taliban, and associated forces, the U.S. military relies on the authority of the AUMF to hold enemy belligerents in military detention in Afghanistan and at the detention facility at Guantanamo Bay. The AUMF is not the only authority the President has to use force to keep us safe. For example, the President has authority under the United States Constitution to use military force as needed to defend the nation against armed attacks or imminent threats of armed attack. This inherent right of self-defense is also recognized in international law. Looking forward, a central question is what future legal framework will provide the authorities necessary in order for our government to meet the terrorist threat to our country, but will not greatly exceed what is needed to meet the threat. As was made clear in the President's NDU speech last year, the answer is not legislation granting the executive unbound powers more suited for traditional armed conflicts between nation states. Rather, the objective is a framework that will support a series of persistent, targeted efforts to dismantle specific networks of violent extremists that threaten America. The challenge is to ensure that the authorities for U.S. military operations are both adequate and appropriately tailored to the threat. And with that, I look forward to answering your questions.
Well, thank you both. I know you stuck to your script, so let me try to get you off your script and go back to my original questions. Is the 9/11 AUMF broken in some way? Is it obsolete? Is it inadequate to the threats we and our friends and allies face today and the foreseeable future? I offer that up for either one of you to answer, or both of you to answer.
Let me begin, Mr. Chairman, and say that I agree with the views expressed on behalf of DOD a little more than a year ago in a hearing before the Senate Armed Services Committee that the AUMF is adequate in order to prosecute and continue to prosecute the current armed conflict against al-Qaeda, the Taliban, and associated forces. To the extent that the United States is threatened by a terrorist group to which the AUMF has not been determined to apply, the President, as we've said, has authority under the U.S. Constitution to defend the nation against armed attacks and imminent threats of such attacks, and therefore has the authority to use military force against groups in order to protect the country from that threat.
Is it obsolete in any way?
Well, I think as the President has observed, we have reached a time now 12 years into the conflict where it's appropriate to review the AUMF with an eye towards its refinement and ultimately its repeal. In my view, I would say what we're looking for and looking to develop is a legal framework for the future that will enable us to continue fighting the terrorists that threaten our country and at the same time to take the country off a permanent wartime footing.
Let me ask you a series of questions to further define this. One is specifically that I hope can have a relatively easy answer, which is on the Iraq AUMF. The U.S. ended its combat operations in Iraq in 2010 and, in fact, withdrew all of its military forces that same year. Since then, Congress has on a number of occasions examined the possibility of repealing the 2002 AUMF authorizing our Iraq operations, but the administration has repeatedly opposed those efforts. Starting with you, Ms. Mcleod, can you explain to the committee, one, whether the administration continues to oppose repeal of the Iraq AUMF, and if so, why? And I'd like to hear your answer to this, Mr. Preston, as well.
Certainly, Chairman Menendez, and once again, thank you for inviting me to testify here today. As you said, the United States has ended combat operations in Iraq, and we've withdrawn our military forces, and I can confirm that we're not relying on the 2002 Iraq AUMF for any military operations, nor do we intend to do so. And I am here to tell you today that the administration now supports repeal of the 2002 Iraq AUMF.
Mr. Chairman, I agree. That's certainly my understanding as well.
All right. That brings to full circle my view, which we shouldn't have been in Iraq in the first place. That's why I voted against it, and I'd be happy to repeal it now. Expressions of approval or disapproval of any of the statements that take place in this hearing are inappropriate, and I would urge the audience to act accordingly. My second question is one I'd like for both of you to answer. If the AUMF were to expire, would the President be able to conduct counter-terror operations, such as drone strikes in Yemen, or other operations against the perpetrators of the Benghazi attack using existing legal authorities? Or would a new or amended AUMF be required to conduct such operations?
Thank you, Mr. Chairman. Let me begin. The AUMF currently, as we've said, authorizes the use of force against al-Qaeda, Taliban, and associated forces. And in Yemen, the U.S. military has conducted direct action targeting members of al-Qaeda in the Arabian Peninsula, known as AQAP, which have been determined to be either part of, has been determined to be at least either part of or at least associated with al-Qaeda. And as you mentioned, Senator, Article 2 of the Constitution provides the President with the authority to target with military force those who pose an imminent threat of armed attack against the United States. And as both a domestic law matter and an international law matter, this authority to act in self-defense doesn't depend on the existence of an AUMF. With respect to the AUMF, though, in particular, we are still in an armed conflict as of today with al-Qaeda, Taliban, and associated forces. And the AUMF continues to provide a source of authority to use military force against those groups when necessary, including associated detention operations. And I would also note that, as I said in my statement, that the President has and uses a range of other authorities to counter terrorist threats, and these include law enforcement, intelligence, foreign assistance authorities.
So your answer, just to synthesize it for me, so because I know when I deal with lawyers I have to get to, is your answer, therefore, is you do not need a new, and from your view, a new or amended AUMF to conduct such operations?
Not for the President to take action against imminent threats to the United States.
Is that your view, Mr. President?
I agree.
Now, the question is acting against the perpetrators of Benghazi's attack a imminent threat?
We can do it.
I'd be happy for either one of you to answer it.
We'll answer. Again.
I know, because you're not going to go to the next senator until you do, so.
Okay. No, I promise I'm going to answer right now. Senator, the United States remains committed to using every lawful tool available to bring the perpetrators of the Benghazi attacks to justice, and we think we have adequate tools to meet that objective.
You think you have adequate tools to meet that objective?
Yes.
And can you give me a sense of what those tools are?
The administration favors bringing those responsible for the attacks to justice through prosecution in an Article III court, and the Justice Department is conducting an investigation to try and achieve that end.
Yes, and if that investigation leads to the identification of perpetrators, how would you act against the perpetrators? Under what authority?
Sir, perhaps I could chime in and say,
Yeah.
I think we have a range of authorities, and our government is committed to making full use of all lawfully available instruments of national power to bring these people to justice and to ensure that they do not present a threat to this country. To the extent that they present an imminent threat of violent attack to this country, the President has, under the Constitution, authority to use force in order to protect this country. Beyond that, to the extent they're presented with a concrete situation, we're in a position to evaluate and reevaluate whether they would qualify under the AUMF. In addition, quite apart from the use of military force and those authorities, there's law enforcement authority to apprehend and bring to justice, try, and prosecute these criminals.
Let me ask you two final questions before I turn to Senator Corker. What authorities does the 9/11 AUMF give the President in terms of authorities to use force that he doesn't already possess in other authorities, including Article 2 of the Constitution?
Senator, as we've said, the President does have authority under Article 2 to protect the nation against the imminent threat of armed attack. However, as the President has said, and I agree with, it's always better and more powerful to have the executive branch and Congress working together on issues.
Yeah, that's not my question. My question is very simple. In order to determine what we do moving forward, I don't mean to interrupt you, but I've got to get a sense, at least from an administration perspective, of what you feel the AUMF gave you that you didn't have otherwise constitutionally or through some other statutory provisions. Because if you tell me that you have all the authorities in the world to go ahead and do everything that the 9/11 AUMF provided, then that AUMF wasn't necessary. So give me a sense of what you got through the AUMF that you don't have under existing constitutional or statutory law.
Senator, if I might answer that, I think it would be fair to say that with or without an AUMF, to the extent that it grants authority for the use of military force against al-Qaeda and the Taliban and associated forces in which we're in armed conflict, and to the extent that those groups continue to pose an imminent threat of violent attack to this country, then the President does have constitutional authority to act. It's not.
So you're telling us that AUMF wasn't necessary?
No, sir.
Other than an expression of congressional support for that engagement?
Not an unimportant point, Mr. Chairman, but I think the point is that these two sources of authority are not, and I don't think were ever intended to be mutually exclusive. And in fact, as your question suggests, they are very largely overlapping when it comes to groups that present a terrorist threat of attack to this country. I'm not going to tell you there are no differences between the two. The concept between an authorization for the use of military force, which names enemy groups, and similar to law of war concepts, enables the use of force against groups, including to degrade those forces without specific reference to imminent threat, is not the same concept or approach as the President's constitutional authority to defend the country against imminent threat, and that parallel international law concept of national self-defense, in which it's rooted in the presence of imminent threat. But I think in terms of the authority to protect this country against these groups, at least some of which present a threat of imminent attack against the United States, both the statute and the Constitution provide authority for the President to use military force to protect us.
Senator Corker.
Mr. Chairman, I have to say, I know several of us were involved in a very bizarre discussion last night. This is continues a very bizarre discussion. I do want to say, for those who are reading the transcripts, Ms. Mcleod, it's unbelievable to me that to answer our questions, you have to find a place, a pre-prepared statement to make, and cannot answer these questions directly yourself, which is troubling to me. But let me just, I think what you've said, if I can synthesize the legalese that you've used, is that the President needs no AUMF to carry out the counterterrorism activities we're carrying out around the world. If I heard you correctly, I think that's what you said. Is that correct?
Senator, I think what I said was he has authority to use military force when it's necessary.
Well,
It's going off, I'm sorry.
I think what I heard you say is he has the authority to carry out the activities he's carrying out without really having an AUMF. And Mr. President, Mr. Preston, with a degree of legalese, has, I think, said something similar. I'd just like to know, yes or no, if the 2001 AUMF was undone, can the President carry out the activities that he's carrying out right now?
Yes, I believe he could, Senator Corker, but
So we really,
I
as a Congress, don't need to be involved in this subject at all.
what I was going to say in addition is that I think when we're talking about sustained military engagements, it's definitely appropriate to get authorizations for use of military force.
Are we in
and that has been
sustained
the
military
practice.
operations now against terrorists?
Certainly
I
against.
know the President a year ago said we weren't. We were doing targeted, I forgot the phraseology that he used, and maybe it was to circumvent this, I don't know, but are we or are we not in a continuous effort against al-Qaeda and affiliated groups? Yes or no? I'd like for the record, she has
Yes,
to
we
look
are.
at the other person to get the answer. I find this very disconcerting today. You want to, I guess you want to answer it for her?
Sorry, I didn't understand your question. Was directed solely at her.
Well, let me, Ms. Mcleod, since you're at State Department and that's who we have jurisdiction over, and I noticed a staffer has given you the answer there. If you would read it for us, it would be great.
Could you repeat your question, Senator Corker?
Does the President have the ability, without an AUMF, to carry out the activities that he's carrying out today against terrorist affiliates of al-Qaeda, and are we or are we not engaged in continuous activity against them?
We continue to be in an armed conflict with al-Qaeda.
So we're in continuous activity. So do we need an AUMF or not?
I think, as we've said, it is important to have.
Important for what reason? Politically or legally?
In part politically, but also because when the Congress has a role to play.
Well, tell me what that role is, because if I understand what you said before, the President can carry out the activities he's carrying out without an AUMF. So it sounds to me like we're pretty irrelevant to the process from the administration standpoint.
That is not true, Senator Corker.
Well, tell me how we are relevant.
We have consulted closely with the Congress on our counterterrorism activities.
Okay. Well, let me change topics. This is not the line of questioning I expected, but I also expected a different type of testimony today on one of the most important issues that our nation deals with. But, Mr. President, do you think, Mr. Preston, excuse me, do you believe that the 9/11 AUMF authorizes you to take action against all terrorist groups that present an ongoing serious threat to the United States? Are there any terrorist groups that you think the AUMF doesn't? It sounds like y'all don't think we need an AUMF at all. So it's kind of becoming an irrelevant question, but are there terrorist groups per the AUMF that you don't think is relevant that you don't have the ability to go against?
Senator, I would not say the AUMF is irrelevant or that Congress's role is irrelevant. The point that I was trying to make is that there's very robust authority both in the AUMF and in the Article 2 in terms of the President's powers.
Are there groups that we cannot go against today, yes or no?
Yes, sir. Let me finish the point, which is to say the President has invited us to focus and engage in dialogue with Congress about the continued necessity and utility of the AUMF or a follow-on legal regime. To answer your question more directly, the AUMF applies to al-Qaeda, Taliban, groups and individuals that are part of al-Qaeda and the Taliban and associated forces.
That wasn't the question. And you're really frustrating me. And I have a generally good nature, but I'm really getting upset, okay? Are there groups today that the administration cannot go against because the AUMF does not allow you to do that? Terrorist groups?
Senator Corker, I'm not aware of any foreign terrorist group that presents a threat of violent attack on this country that the President lacks authority to use military force to defend against as necessary simply because they have not been determined to be an associated force within the AUMF. In other words, if a group that is not or may not be covered by the AUMF presents a threat of violent attack to this country, the President does have authority to take action, including military action, to protect the country from that threat.
So there are groups that didn't exist at the time but are affiliated with al-Qaeda that today are covered by the 9/11 AUMF, even though they didn't exist at the time.
That's correct, sir. The way I look at it is the AUMF, not by name, but essentially identified the Taliban and al-Qaeda as our enemies, and that other groups, and most notably AQAP, which has emerged since that time, have made themselves our enemy by joining with al-Qaeda and engaging in hostilities against our country.
Yeah. So the group that I discussed in my opening comments, ISIS, which is split from al-Qaeda, that is not affiliated with al-Qaeda, and actually I heard administration officials had expressed concerns about their ability to deal with them in Syria and as they migrate back across into Iraq. Are you saying that even though they're not a part of al-Qaeda, you have the authority to go against them?
Senator, what we would do if we were presented with a need and an opportunity contemplating the use of military force would be to examine what our authorities were. That would consist, first of all, of determining whether or not they would fall within the AUMF as an associated force using the definition that we've provided, or if not, if they present a threat of imminent attack on this country, we could rely on the President's inherent constitutional authority.
So you wouldn't rely on the AUMF, he just has authority to do whatever?
We could rely on the AUMF to the extent that this group or any other group is covered by the AUMF.
But I thought you just, yeah. Mr. Chairman, I find this bizarre, and I hope that our next group of witnesses is a little more clear. I do want to say that both of you indicated the President has asked you to engage with Congress on this. To my knowledge, I'm the ranking member of this committee, and along with other members on this committee have expressed interest in the AUMF for some time. I have had no reach out from the administration. My guess is the chairman is not. I'd love to know if Tim or anybody else has. I know everybody's expressed concern. So that is another line of hollow comments from this administration. You have reached out in no way to talk to us about refining this. Or I understand you guys want to refine and replace some, or repeal, refine and repeal, and I do hope at some point you'll define what that is. But this is a hearing that's not particularly gratifying, and I do look forward to talking to you more in the future.
Sir, we look forward to engaging with you and the committee and the other cognizant committees as well. I will say, since the President's speech, the administration has devoted a great deal of energy to the focusing on the drawdown in Afghanistan and what the mission and presence will be there, to redouble the effort to clear detainees from Gitmo towards the closure of that facility, implementation of policy guidance concerning counterterrorism operations outside of Afghanistan. We have tried to be in continuous dialogue with congressional committees on that, including on the BSA and such. And those are the precursors to focusing on possible repeal and, in the meantime, refinement of the AUF. And we've made progress, particularly I can speak for we agency lawyers, in focusing on what sort of legal regime, what sort of future legal framework might govern. And we very much look forward to engaging with the committee and other committees on that when the administration is prepared to engage in that discussion in earnest. But a good deal of this is premised on finalization of what the circumstances, the mission and presence in Afghanistan will be, and that still remains to be finalized.
Mr. Preston, I don't know why I keep calling you Mr. President.
I'll try not to get used to it.
Yeah. That is that last statement about waiting to see what we're going to do in Afghanistan after this presidential election is one of the most bogus, lacking of substance comments I have ever heard before this committee. It has nothing to do with this AUMF, nothing. And I have to tell you, Mr. Chairman, I know we were involved in a discussion last night. I think the administration is totally unprepared to discuss this issue, totally unprepared to decide how many troops we're going to have in Afghanistan, continue to hide behind this presidential race that's taking place in Afghanistan. We all know what the outcome is going to be. And I just want to say that you discredit our country with statements like you just made, that we are waiting to see what we're going to do in Afghanistan to determine whether or what an AUMF needs to look like. So I'm very disappointed in your testimony. I'm disappointed in the White House's ability to deal with substance, but to continue to deal with the optics of the way things are going to look. And I do look forward to that engagement whenever it occurs. It hasn't occurred in a long, long time.
Before I turn to Senator Kaine, I think Mr. Preston's comment is not necessarily the way you took it, is not necessarily the way I took it in terms of looking at an overall AUMF. I actually have a line of questioning that I wanted to turn to other members before that I want to come back to, specifically on Afghanistan. That might be, I think, what was meant. I do want to just ask one thing, the prerogative of the chair, before I turn to Senator Kaine so I don't lose a train of thought. Basically, to now, what I hear is that there's no reason why the administration would oppose the repeal of the 9/11 AUMF totally, because you basically say the President has all the authorities notwithstanding the AUMF.
Mr. Chairman, I think that's precisely the task that the President has put before us in his May into You speech, which is to examine that question, whether and what would be appropriate in the way of refinement and ultimate repeal of the statute. We're not here today calling for the immediate repeal of the statute.
No, I know you're not
We're
calling
here-
for it, but your answers so far to both myself and the ranking member would indicate that there is a view that really you have all the authorities, constitutionally and otherwise, outside of the AUMF. So
I think what I've tried to address is in terms of fundamentals and the fundamental ability to protect our country against imminent threat of attack. That is not to say that there aren't pros and cons, advantages and disadvantages to having a statutory authorization versus relying on the President's authority. That's precisely what we are working through now at the President's initiation,
Well,
and looking forward to engaging with the committee.
I appreciate that both of you want to preserve to the maximum degree possible all presidential authorities. I get that. I understand that. But we are trying in a good faith effort here to actually be helpful, not harmful. Senator Kane's been very involved in this issue. I look forward to his question.
Thank you, Mr. Chairman. And to the witnesses, these are hard questions, but they're not gotcha questions because we're trying to figure out what to do with a law that Congress passed. I have a number of concerns about the AUMF. Congress put in it no temporal or geographic limitation. Congress did not put such limitations in the AUMF. Administration witnesses testified last year before the Armed Services Committee opined pretty blithely that the war so declared would likely last another 25 or 30 years. I don't think that's what Congress intended. I have concerns about the breadth of the definition that both administrations, the Bush and Obama administrations, have used about the associated entities to al-Qaeda that could be targeted. I have concern about allowance of military action against those who intend harm against coalition partners, which is a huge group of partners. That was not part of the AUMF language. And I have some concern that Congress rejected a notion of preemptive war in drafting the original AUMF, but the interpretation, especially of the coalition partners and associated entities phrases, have essentially allowed preemptive action in contravention of what Congress originally intended. But to my colleagues, this is something that I think only we can solve, because as we've heard from administration witnesses in the Armed Services hearing last year, an executive is comfortable with a carte blanche. Why wouldn't they be comfortable with a carte blanche? And they're not going to move, I don't think, as expeditiously to rein in a carte blanche as we probably need to. So if there's going to be action taken here, it's up to Congress to take it. And of course, we want thoughts and guidance and opinions from the administration so that we take the right action, not the wrong action. If a bill was introduced today, you've indicated that the administration supports the repeal of the Iraq AUMF. If a bill was introduced today to repeal the 91401 AUMF, would the administration's position be support, oppose, or I don't know?
As of today, Senator, I think the answer is we don't know.
Is that fair, Mr. Preston?
What I would say, Senator Kane, is that the prospect of repealing the AUMF is precisely what the President has functionally asked us to do, and that the administration wants to engage with Congress to decide.
And I follow that.
And
please,
if I could
Ms.
just
Mcleod.
say, and I think we're not here to say that it should be repealed today, although it's clear that that is the President's ultimate goal.
Well, so I asked this question because the President did suggest that we should engage around these questions in a speech that he gave in May of 2013. That's 1 year ago. So as of today, 1 year later, if a bill was introduced to repeal the AUMF, the position would not be support and the position would not be oppose. In your testimony, the position would be, I don't know what the administration's view would be about such a proposal. Is that, Ms. Mcleod, that was your testimony, Mr. Preston?
We did not come here this morning equipped to answer that question.
Okay.